In the name of Almighty Allah, I welcome the participants in today's session, Mr. Mehdi Raza, Mr. Mutahir Hussain, and Ms. Aroma. In today's session, basically, two primary concepts of Companies Act 2017 we will be discussing. One of the very primary concepts when we discuss the companies, incorporation of companies and the management of companies. Regarding companies, this is a very interesting phenomenon that it is on one part appears to be fiction, and on the other hand, it is the reality that the company is a separate legal entity. That precisely means that we segregate company from its directors or board of directors. Company has its individual value. Members of board of directors, they are natural legal persons. Company itself is a legal person and it enjoys separate legal entity. The very definition of this point, I'd like Mr. Mehdi Raza to share with the participants.
Separate legal entity. A company has a legal entity separate from its members. It has its own name and seal. Its assets and liabilities are separate from those of its members. The creditors can recover their loan only from the assets of the company. Similarly, the company is not liable for individual debts of its members. A company can sue and can be sued. It can own property, borrow, loan, have a bank account, employ people, and enter into contracts.
That's right. If we segregate the points actually given in this paragraph, first of all, this is pretty clear that company has its own legal entity and that is segregated from the entity of its members. Company has its own name and seal. And the best part is that company's assets and liabilities are separate from those of its members. And in order to understand this very point, we have today from English jurisdiction a precedent that is Solomon versus Solomon, and two judgments rendered by the high courts in Pakistan. One is a very latest one rendered in this year, and one is from the year 2017. And the very concept discussed in those judgments, in order to understand the very concept which is just narrated here, and that is its assets, I mean company's assets and liabilities are separate from those of its members. So in these cases, companies went for liquidation or there was a claim against the company, and in order to satisfy that claim, matter went to the court of law. The claimant, he lodged a suit against the company, and it was held that it can only be satisfied from the very assets of the company, and the assets of the members are not amenable for discharging the liability of any claimant. The creditors can recover their loans only from the assets of the company. This further clarifies that if there is any creditor who has a claim for any loan or he has any debts to recover from the company, so he can directly sue the company to make that recovery. And company is not liable for individual debts of its members. Vis-a-vis, when we said that members are not liable for the debts of the company, likewise, company is not liable for the individual debts of its members. For instance, there are 7 members board of directors. One of the director in his personal capacity borrowed some money from a banking company or from any individual. The company is not liable to pay back, though the very person is the member board of directors of the said company. Likewise, a company can sue if company intends to make some recovery from some defaulter, company can directly file a suit in its own name. And in the same manner, some individual who intends to make recovery from the company can directly sue the company. And the company can own property, borrow loan, have a bank account, employ people, and enter into contracts. In these precedents, we have searched for this session today. We will find that there is a contract entered with the company, with another company. The company entered into an agreement with another company. And in order to satisfy that contract, or in order to solicit the performance of that contract, the plaintiff filed a suit against the company, and but was entrusted to make that claim through the members board of directors, and it was held that no, this is solely the company's liability. So this is a concept, in fact, enshrined in law in terms of companies, that companies are separate legal entities. Let me now take up the second point, and the second slide I'd like to share in this context is another point of law, and that is limited liability. And that is limited liability. Let me share this slide before we discuss this. Here we go. Ms. Aroma, please read limited liability.
Limited liability. Limited liability is a legal status where a person's financial liability is limited to a fixed sum, most commonly the value of a person's investment in a corporation, company, or partnership.
That's right. Especially the purview of our discussion today is the limited liability of its directors. And their liability is limited to the extent of their investment only, and their personal assets cannot be dragged into any claim made by the claimant. Or in order to satisfy the claim, the personal assets of the directors are not amenable to any recovery proceedings. Only the recovery can be made through the very limited liability undertaken by the directors or the members of the company. And that is normally to the tune of their investment only. So this is a concept of limited liability. And now let me take you to the next point. That is now one of the definition, actually. Before we start discussion on the precedents, there is an important definition which we need to understand. Mr. Mutahir, please read this definition.
Sure. Limited liability. Limited liability is a legal status where a person's financial liability is limited.
Just a moment, Mr. Mutahir. Let's see if actually we are now for the definitions, actually. So debenture.
All right, now we're.
Yes, here we go.
Debenture, yes. Debenture. Debenture is a long-term security yielding a fixed rate of interest issued by a company and secured against assets.
Right.
What is the okay?
Let's pause here for a minute. A long-term security yielding a fixed rate of interest. You see, in companies, people make investments. First, very simple mode of investment is that if it is a listed company and its shares are traded in Pakistan Stock Exchange, any individual through a brokerage house can buy the shares. This is the very easy way of, or ordinary way of investing in a company which is listed on stock exchange. Companies which are not listed on stock exchange, but you still intend to make an investment, in those companies. Those sort of companies, or even listed companies, they issue debentures. These are secured, in fact, sort of investment, and the rate of interest, unlike buying of a share or subscribing the shares of a company, as you know, the rate of return is not certain, and sometimes if there is a market is in recession, one can lose one's investment. On the other hand, if you have invested through debentures in a company, then of course that is a secure investment, and you will get a fixed rate of profit on your investment. And generally what happens, that if company goes for liquidation, or if it happens that it is required to wind up the company, then there is a sequence given in terms of payment of those who are claimants, creditors, or secured debenture holders. Let's read this once before I'll explain this point. Mr. Mutahid, please continue.
What is the order of who gets paid first during a corporate liquidation? First of all, the secured creditors. If a company goes into liquidation, all of its assets are distributed to its creditors. First of all, government taxes are paid. Should I continue?
Please.
Among non-governmental creditors, secured creditors are the first in line. Next are unsecured creditors, including employees who are owed money. Shareholders are paid last.
That's right. Here, these secured creditors are basically debenture holders. They are the one who have advanced some, or who have made some investment in a company, but that is through debentures, which is secured actually against assets of the company. Now, bearing in mind three primary concepts. First of all, limited liability. Number two, separate legal entity. And number three, the definition of debenture or secured creditors. Once we have in mind all these three concepts, it will be far easy for us to understand the case law, in fact, which is relevant to the discussion we are making. Let's begin with Solomon versus Solomon, and then we will move on to Pakistani courts' decisions. Mr. Mehdi Raza, please. Let me share the slide. Here we go. Yes, please.
Solomon versus Solomon and Company Limited. The principle of separate legal entity was explained in the famous case of Solomon versus Solomon and Company Limited. Mr. Solomon owned a leather business in England. He formed a company called Solomon Company Limited and sold his business to it for $39,000. Solomon, his wife, and 5 children became members of the company. His 2 sons became directors, and Solomon became managing director. The purchase consideration was paid by the company by allotment of 20,000 shares of 1 each, 10,000 secured debentures, and balance in cash to Mr. Solomon. 1 share of each was allotted to 6 members of his family. After some time, the company went into liquidation. Company had assets 6,000 and liabilities including debentures to Solomon 10,000 and unsecured creditors 7,000.
Pause here for a minute. Basically, what really happened, initially Solomon was a sole proprietor of the leather business. He one fine morning bought this idea that if I will go for, if I will convert my sole proprietorship into a private limited company, then the liability will be limited. But actually he designed this all. He had a mens rea or a bad intention in his mind. So in order to follow his plan, he converted into his sole proprietorship into a private limited company and introduced his wife and 5 children as members of the company or members of the board of directors of the company, and sold one share or asked them to subscribe one share each of the company. Now, here, if we look at the situation which erupted as he planned, actually, that after some time, the company went into liquidation. Company had assets 6,000 and liability, including debentures to Solomon, 10,000 and unsecured creditors, 7,000. So basically, Solomon planned this all. He held secured debentures or secured, in fact, assets in his favor, in his name, to the tune of 6,000 shares of the company. These were the debentures. And as I explained earlier, that in case of liquidation, if you intend to wind up your company, there is a scheme of repayment given in the law. And that scheme is that, first of all, the company which is subject of liquidation will pay off government taxes. And then the second in line is debenture holders, and then unsecured creditors. So what Solomon planned, that he was holding the debentures, company went into liquidation, and result will be that he will not only eat his cake, but he will have it also. So his planning was that since I am the debenture holder, so in terms of liquidation, I will get my debentures back first, and then nothing will be left. So ultimately, unsecured creditors will bear the loss. So this was his planning. So those unsecured creditors, actually, they dragged Mr. Solomon to the court of law. And then you will find that in 3 tiers of judicial hierarchy, the matter was adjudicated, and finally a decision was made. So let's continue reading to find more about this happening. Yes, please, Mr. Mehdi, continue.
Thus, assets were short of liabilities by 11,000. The unsecured creditors claimed priority over debenture holders on the ground that the company and Solomon were the same person. The court held that the company is separate from its members and secured debenture holders will be paid first.
That's right. So in this case, though the unsecured creditors, they brought this matter before the court and said that actually this was only a sham arrangement. This was with the mindset of defrauding the unsecured creditors. So this was the strategy of Solomon, because Solomon and Solomon's company are one or the same things. But here the court of law held that no, Solomon's personal assets are not amenable to the claim of creditors. And the claim of creditor can only be satisfied with what is left over. So in this case, the assets of the company were 6,000 shares. Solomon, with his planning, actually, was already holding much more than 6,000 shares as his debentures. So ultimately, he was paid first as debenture holder. It was not considered that Solomon is the chief executive officer or chairman, board of directors, or owner of the company. And this is how he has planned this strategy. I have actually the whole precedent that the decisions made by the High Court and then finally House of Lords. That is in a separate slide. We will share it later. Let me share with you one of the precedent from Pakistani jurisdiction to understand limited liability concept and to understand separate legal entity understanding. So here we go. This is the latest judgment, 2021. CLD is the acronym for corporate law decisions, and page of CLD, the reported book of judgments, is 521. This judgment is rendered by Lahore High Court, Lahore. The title of this judgment is Fiza Developers Limited, Authorized Private versus SM Hotels Limited. So let's read the operative part of this judgment. This is not the whole judgment. The whole judgment will be made available to you through CMS so that you can go through it at your own time. Let's ask Ms. Aroma to do the reading, please.
Fiza Developers Limited Authorized Private versus SM Hotels Limited. Winding up of company by court. Company when deemed unable to pay its debts, jurisdiction, powers and procedure of court under Companies Act 2017. Determination as to company's inability to pay debts, scope, petitioner sought winding up of the company, inter alia, on ground of an arbitration award in favor of petitioner, which amount was a debt that the company was unable to pay. Validity. Winding up petition could be based on an arbitration award which had special significance. However, Company Court did not enforce such award but merely went into question as to whether any debt was presently payable and whether a dispute was raised which was prima facie bona fide or not. Award was to be relied upon by way of an additional piece of evidence of debt due to a party. Decree in favor of an other creditor to the company had been passed, coupled with other suits for recovery pending against said company along with passing of arbitration award. Enough proof existed to satisfy court regarding contingent and prospective liabilities of company and its inability to pay debts. Company had not filed Company had not filed its financial statements or annual returns, and thus per S.301D of Companies Act 2017, it was also liable to be wound up on such default on basis of record and fact that company's business operations had remained suspended over the last decade. Circumstances in S.301 of Companies Act 2017 were triggered, and it was just and equitable that company be wound up. High Court directed that the company be wound up in accordance with provisions of Companies Act 2017. Petition was allowed accordingly.
Right. So this is section 301 of Companies Act 2017. And actually, in this case, the complete citation will be shared with you on CMS. You will have an opportunity to go through that. And now let me share with you another citation. This is basically, again, clarifying the very fact that the limited liability concept is shared in this judgment. The title of this judgment is Arshad Salim versus Civil Aviation Authority. It is reported in the year 2011 journal, CLD, Corporate Law Decisions, page 1171. Please, Mr. Mutahir, share this citation.
Okay, sir. Arshad Salim versus Civil Aviation Authority, 2011, CLD 1171. Arshad Salim, a director of TDI International Holding Pvt Limited, made an agreement with CAA for installation of advertisement and hoardings. CAA sued the director for payment of dues. The court held that director who signed the contract on behalf of the company cannot be held personally liable for acts of the company because company is a separate legal entity.
Absolutely. Now, this judgment actually very squarely clarifies these 2 points: limited liability. The director of the company, though he had signed the agreement on behalf of his company, that was TDI International Holdings Private Limited, with CAA, that is a government authority, aviation authority actually. That aviation authority signed an agreement, and on behalf of TDI International, one of the directors signed it. Subsequently, aviation authority filed a claim against the director for the payment of dues, and the director went to the court of law against that claim, and court held that yes, Mr. Arshad Salim is not liable to pay, though he signed that agreement, but he did it on behalf of the company, and company is liable to pay that claim. Mr. Arshad Salim, in his personal capacity, is not liable. Moreover, this was held in this judgment that company is a separate legal entity, and company is since company can enter into an agreement, and company is in fact squarely liable to discharge its liabilities also. So this was the citation in this case law. So with these words, I'd like to have a quick short session for any questions before we conclude. Yes, please.
So I have a question. I
Please.
couldn't really get to the verdict of the Solomon case. I think we haven't even read about it yet. But was a smart move, having the debentures of the company. But considering as investors, wouldn't the investors already notice something like that, that the owner is actually getting the debentures instead of the shares? There is something fishy in the business going on, because
That's
that
right.
would be a clear sign.
Yeah, Mr. Mutai, this is the whole, in fact, gist of the decision, and it will be shared with you on the CMS. So you'll be able to go through it in your own time, and you will find ultimately that the court of law finally found that mischief in the strategy of Solomon. And if I just quickly go through the final decision by the House of Lords, it was the company is at law a different person altogether from the shareholders. And though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profits, the company is not in law the agent of the shareholders or trustee of them, nor are the shareholders as members liable in any shape or form except to the extent and in the manner provided by the Act. That was the final decision by the House of Lords. You will go through it and you will find that actually there is a veil between the members and the company. And that veil of incorporation, it can be lifted in some circumstances, but in Solomon versus Solomon, I leave it up to your reading actually, that let's come up with this answer in a later session, that whether the veil was lifted and Solomon was personally held liable to pay off to the unsecured creditors. So with these words, I thank you for your participation. All the best. Allah Hafiz.